Committee. Good morning, conferees and committee. Appreciate all of you being here. In the interest of time, we're going to limit our testimony to 5 minutes apiece. If you do that, so that everybody will have time to get their words in. First item of business, introduction of bills. Do we have anyone introducing a bill? Ed?
Thank you, Mr. Chairman. My name is Ed Klump. I'm here representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. We have a bill request, and it is RS 2422. RS 2422. Mr. Chairman, what this bill does is it has to deal with the committee that is created by legislation that oversees the law enforcement memorial out here on our grounds. And that is comprised right now of 10 members, and they are all law enforcement or elected officials. What this bill proposes to do is to add one more seat to the voting membership, and that is a member of the Kansas Concerns of Police Survivors, which is an organization comprised of family members of officers that have been killed in the line of duty. And we think they need a voice on that committee. Not to say that it hasn't run well, but you can see we have a beautiful memorial out there, and they've done a spectacular job, but this voice needs to be there also. So that's our request.
Very good. Thank you. Committee objections? Seeing none, bill is entered. Thank you very much. Okay, we'll open the hearing on, well, first, is there anybody, Lance, is there anybody on WebEx this morning? Okay. Oh, he's right here. Okay. Very good. Well, we'll open the hearing on HCR 5020, proposing a constitutional amendment to amend sections 4 of the Kansas Bill of Rights to recognize the right to bear arms as a fundamental right that includes the possession and use of ammunition, firearms accessories, firearms components, and any restriction on such right are subject to strict scrutiny standard. So with that, our first, oh my, go ahead. I'm sorry, I took Mike's job. Anyway, no, you're fine. Thank you, Mike, for that. Sorry about that. I guess it's been a while since I've heard a bill, so I've forgotten how we do things. Okay, with that, the first proponent will be, okay. Are there any questions for the revisor? Representative Hoy.
Thank you, Mr. Chair. Oh, thank you, Mr. Chair. I would appreciate if you could walk us through strict scrutiny and how that would be applied should there's 4 other states that have adopted this, and they have faced lawsuits from convicted felons for wanting their gun rights back. And could you walk us through how that could be applied in the courts and give us a better understanding of what strict scrutiny means, please?
There are 3 levels of scrutiny that when you have a constitutional issue, and one would be kind of a reasonable basis. Another, the next level would be intermediate scrutiny or whatever. And the highest level is strict scrutiny, where you have to have a compelling interest to regulate the rights. So that's a thumbnail sketch of the different kinds of scrutiny. I'm not familiar with, I mean, I can provide the information about court cases and so on, but off the cuff, I can't.
Thank you, Mr. Chair. I think would be helpful to have some more information on that. And I would also note that since this is a House concurrent resolution, there is not a fiscal note attached to this. And I'm not sure how difficult this would be, but I would request if research could look into how much this has cost. For example, the state of Louisiana that has had, close to hundreds of millions of dollars in lawsuits. And I don't have evidence myself to say it could be that costly, and but I am cautious enough about this that I would like to know how much this could cost local and state governments defending their existing convicted felon prohibitors or city ordinances that are reasonable, in my opinion, to public safety. How much could that cost them defending themselves in court?
Representative Clayton.
Thank you, Mr. Chair. And sorry for being late, bad elevator juju. I'm sure we're all used to that today. So, Mr. Advisor, so I have a question. I haven't had the chance to look this up because, again, I was tardy. Is there a statutory definition that defines ammunition? Because I'm not really seeing it here in this bill, but do we have, what is ammunition under the law?
I can look it up here real quick. I will make a comment. This provision of the Constitution was amended back in 2010 to add the language that's in the first sentence. A person has the right to keep and bear arms for defense of self, family, home, and state for lawful hunting, recreational use, and other lawful purpose. That amendment passed overwhelmingly. 88% of the voters voted in favor of it. So, and I think you'll have more information about that from the conferees.
Was that the right to hunt and fish?
It's for lawful hunting and recreational use and for other lawful purpose.
Committee, further questions? Seeing none, I want to recognize Representative Nguyen, who is filling in for Representative Highbarger. So thank you very much for being here. Welcome to committee. Okay, now I think we have everything in order to start the hearing. So the first proponent is Attorney General Chris Kobach. Thank you for being here, General.
No, it's not. Okay. Yeah, thank you, Mr. Chairman and members of the committee. Good morning. I offer this testimony, obviously, in my capacity as Attorney General, but as some of you may know, I taught for 15 years as a professor of constitutional law at UMKC Law School and taught Second Amendment law. So hopefully I can offer some answers to questions you may have about how this fits into the legal framework we have right now. I'm strongly in favor of HCR 5020. I believe that the robust protection of our right to keep and bear arms is not only consistent with both our state and federal constitutions and the intentions of the framers of both the state and federal constitutions, but it's also essential to a free society and the protection of other constitutional rights. But I think the best value I can add for this committee is to try to explain what this constitutional amendment would do. What effect would it have? And I think in order to do that, you need to begin with two things. What power does a state constitutional amendment have in litigation? And secondly, you have to look at this in the wake of the Supreme Court's decision on June 23rd of 2022 in the case of New York State Rifle and Pistol Association versus Bruin. Okay, so let's look at the first thing. What can a state constitutional right do? A state constitutional right can elevate the level of protection for whatever right we're talking about. So it doesn't matter whether we're talking about the right against searches and seizures, the right to worship, the right to free speech, the right to keep and bear arms. If the federal constitutional right takes you here, the state constitutional right can add more protection. Now, let's say that the state constitution doesn't say anything, or the state constitutional right protects it to a lower degree. It won't work the opposite way. It won't reduce what the Second Amendment does for you, but it can add more on top of the Second Amendment. The second thing you should know about state constitutional rights, they can be preempted. So a federal statute can override a state constitutional provision. However, a federal regulation promulgated by, say, ATF cannot override a state constitutional provision. So that's the first thing we want to keep in mind. Second, we need to talk about the June 2022 case in Bruin. In that case, the Supreme Court recognized that the Second Amendment does protect the right of a person seeking to get a concealed carry permit without a special reason. New York had didn't have a shall issue law. They had a may issue law where a state official could basically decide whether you had a good enough reason to have a concealed carry permit. The Supreme Court struck it down, but the Supreme Court did more than that. The Supreme Court set a very high constitutional standard for protecting Second Amendment rights. Now, In DC versus Heller in 2008, the Supreme Court for the first time affirmed that the Second Amendment is an individually held right on par with other individually held rights. Prior to that, there have been theories that it could only be held by members of the militia or National Guard, and there are all kinds of theories. But the Supreme Court said, no, it's like all the other constitutional rights. It was presumed by many that that would mean that strict scrutiny would apply. Whenever in strict scrutiny, to answer your question, strict scrutiny means that the law is presumed unconstitutional, but the government has the burden, if the government is to prevail, must show there's a compelling governmental interest and that the law is necessary to serve that interest. Very high standard. But what happened is several of the federal circuits applied something closer to intermediate scrutiny, which is that the government has an important government interest and that the law substantially advances that interest. Then fast forward to last year, or 2022, with the Bruin case. The Supreme Court said, many of us thought, oh, they're just going to say no, strict scrutiny applies. They went one step even higher. And they said, if you can show that this right falls within the text of the Second Amendment, then the law is presumed unconstitutional. The only way the government can win is if the government can show that the regulation at issue is consistent with regulations that were understood to be okay at the time of the framing. In other words, understood to be okay in the 1789 to 1791 period. That's a higher standard. It's an absolute standard. There's no balancing as there is with strict scrutiny. There's no weighing of the government's compelling interest. Okay, so what does that mean for this Kansas amendment? What it means is that we would be adding a strict scrutiny standard for the state level. And I think that's a good thing if you believe in protecting gun rights, because if for some reason a regulation failed to meet the history and text test that the Supreme Court just created, again, this is a freshly created test in 2022, you still might be able to achieve pass the strict scrutiny test. In other words, the right might be better protected conceivably under strict. So you basically have two very strong tests protecting the individual. In litigation like this, the plaintiff or the person asserting the constitutional right will usually assert every constitutional claim he has. So he will bring both a Second Amendment claim and a claim under the Kansas Constitution. So by adding the strict scrutiny standard, in addition to the Supreme Court's new text and history standard, you're giving the person asserting the gun rights the best possible chances. The other way it'll affect litigation is that this constitutional amendment specifically mentions ammunition and components and accessories. I think that's a good thing. The Supreme Court has yet to address whether the Second Amendment extends to those things. I think it does, but there's no case law yet in the United States Supreme Court. So it does two things. It gives the individual asserting the right the strict scrutiny standard in addition to the Supreme Court's new standard. So you've got two different ways of prevailing, and it also expressly protects accessories. I would end my testimony, and I'm certainly happy to take questions, with one note of history, and that is Kansas history. As was mentioned in 2010, the voters of Kansas did ratify the amendment of the text of this amendment as it stands now. But what you may not remember is that 88.2% voted yes. That's the highest percentage voting in favor of a gun rights amendment of any state ever in United States history. Kansas set that high bar in 2010. Second place goes to West Virginia in 1986 with their amendment when they hit 83.6%. I just mentioned that to say that the voters of Kansas, at least in 2010, were strongly in favor of protecting our constitutional right to keep and bear arms. I anticipate that they will be strongly in favor of it this year as well. Thank you.
Very good. Thank you for that. Committee, are there questions? Representative Hoy.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for the testimony. I do think that is helpful to understand how this is applied in court, but I do want to also paint the picture of when we're talking about the cases going before the courts and the cases that would be subject to strict scrutiny. A lot of these that the other states are seeing, they're not coming from law-abiding gun owners. It's coming from convicted domestic abusers, convicted felons. And there's nothing in this amendment that would protect our convicted felon prohibitor. There's nothing that would that states in there that those are the types of laws that we would want to protect. And so I am very concerned about how costly that could get at the expense of the taxpayers to be defending ourselves against potentially violent criminals. So what are your thoughts on how that is, even if it does withstand Other states that have done this have seen floods of litigation, and I am concerned about some of these laws that have passed. I mean, the domestic violence bill passed overwhelmingly from the legislature. That's something we've all agreed is a common sense gun law that's already on the books, and this could potentially take some of those laws off of the books.
I respectfully disagree that it would take those laws, or that it would have the effect of, nullifying those laws in court if they were challenged. The reason is that in both federal Second Amendment jurisprudence and in the text of this case, it's always been assumed that historically and today, the government, whether it be the federal government or the state government, has the right to take away from a felon his right to keep and bear arms. That that right can be sacrificed, and that the loss of that right is an element of punishment that can be imposed. And I think if you look at the existing wording of the Kansas constitutional provision, it has those words lawful, and that's important. Right to keep and bear arms for defense of self, family, home, and state, for lawful hunting and recreational use, and for any other lawful purpose. That's the existing language we have. That doesn't change. And that lawful purpose, lawful uses, is suggestive of what we've seen in other cases involving the federal constitutional Second Amendment, where because you have acted unlawfully, you have lost or forfeited your right to keep and bear arms. So I don't think this would change or undermine federal. Well, it certainly wouldn't undermine federal statutes. And bear in mind that it's federal statutes that have the effect of depriving most people of their right to keep and bear arms. It's usually not, although the state. We do have a statute that says that a felon can, it is a felony to be in possession of a firearm when you are disqualified for holding that firearm. That's parallel to a federal law, which would still be in effect. So the federal statute wouldn't be affected by this Kansas constitutional change at all.
Correct, but for clarification, if we don't have that mirroring law like we do with the domestic violence language in our state statutes, then it takes a local and state law enforcement aren't really able to enforce it. So it'd be up to federal agents, which I would also caution law-abiding gun owners, if this would go into effect, they could still end up in federal prison, even if the state doesn't have a case against them. But to clarify on to the protection of these existing prohibitors, if even a moderate judge, if there's one component of something that they strike down that is being of a law or statute that's being challenged, that could strike the whole law. It wouldn't just be one part of it. So if we're looking at our domestic violence, if a domestic abuser sues the state, if this goes into effect and says that our domestic violence law is unconstitutional to the Kansas Constitution, that could potentially put that at risk. I mean,
well, as you go, it depends on the law. And I assume, I don't have it in front of me, I'll assume that our domestic abuse statute has a severability clause. You guys routinely put severability clauses at the end of every statute, virtually every statute you pass. The reason you put that there is so the court can sever the offending provision and the rest of the statute stays. I'm guessing we have a severability clause. We have with most of our statutes, but that would prevent the whole domestic violence statute from going down.
Very good. Thank you. Representative Clayton.
Thank you, Mr. Chair, and thank you for being here, Mr. Attorney General. I figured very rarely do I actually get to have the Attorney General in front of me, and I know that you have a very solid education, so I know that you will be able to clarify this for me. I'm not even trying to troll you here. I legit want to know. I looked up our definition of, basically like our types of firearms and things that are illegal. The only ammunition that is illegal in Kansas under Kansas statute is bullets that have plastic interiors, right, or plastic casing. So that's, it's KSA 236301. If you all want to pull that up in your laptops, section 6 that covers ammunition. But so this would be a constitutional amendment, right? And so ammunition is mentioned. I know that there are federal regulations against armor piercing ammunition. Would this override those? Because I'm kind of freaking out here. So can you assuage my concerns on that, please?
So all federal statutes governing ammunition and the very high, more deadly military type ammunition would still apply. The state constitutional amendment would not override a federal statute. I would also just say, just as an aside, the the definition armor piercing is not like it's not like a bright line, right? There are 5 different categories of body armor you can wear, and I know this personally because KBI has given me all these options, and here's what you do. So there are different levels, and then bullets, of course, have many. There are many grades of bullets. It's not like one that just crosses the line and becomes armor piercing. So anyway, there are federal restrictions, statutory restrictions on the most potent bullets. Those would remain in place.
But just to follow up here, so there are federal restrictions against the most potent, the most armor piercing, but there are some that are armor piercing light that wouldn't be made illegal.
I mean, I'm not a armorer, but I can tell you that some, those of you who do shoot know that some bullets will, if it's a solid projectile, may actually pierce the armor, but they may not be as effective. They might be as deadly because it's a solid. It doesn't, come apart when inside the target. So it'd be hard to answer your question with a definitive yes. This type of bullet, which is really deadly and will go through the armor, would change. But the general answer to your question is nothing changes because most of these restrictions, virtually all of these restrictions, except for the Kansas one you mentioned, are federal statute anyway.
All right. Well, you have raised some concerns just regarding the different types of armor piercing bullets. I was really raised to respect and protect law enforcement. And so I just don't feel comfortable supporting this. But I do appreciate you being here today, Mr. Attorney General. Thank you.
Welcome.
Representative Ruiz.
Thank you, Mr. Chairman. And it's good to see you again, Mr. Colbach. Has been any specific threat to the Second Amendment rights to the citizen of Kansas that precipitated this bill coming forth?
Well, I think there's, it's hard to define a specific threat. I think if you think about threats to the Second Amendment, usually, unfortunately, those often come from the government, typically the federal government. And in the current administration in Washington, the ATF has been pressed to stretch the limits of its statutory authority and do things that the federal statutes, in my opinion, do not authorize. They're going beyond their statutory authority. And so they've done a host of things. For example, Kansas is, we are leading a 25-state group that are saying there's currently an ATF proposed regulation that would essentially make person-to-person individual transactions between 2 friends or between family members, if there is any profit whatsoever made in the sale of the firearm, that would be illegal unless the seller obtains an FFL, a federal firearms license. So the ATF has been, in the last 3 years, aggressively redefining the regulations, They've been challenged in court. And so I think that's the threat, is that if you have a federal regulatory agency that's going beyond its statutory authority and arguably violating the Second Amendment, we'll see it when these cases get to the high court, then that's a threat to Second Amendment rights. And again, a state constitutional amendment does have effect against a regulatory agency, in particular when that agency is exceeding its statutory authority. It does not trump Congress, though.
Getting back to the accessory part of the bill, what about bump stocks?
I think bump stocks are fairly categorized as an accessory. However, as you know, that case is in litigation right now, and the question is, are bump stocks within the protection of the Second Amendment? So that might be something that would be categorized as an accessory. I think the courts are probably going to view it that way.
And my final question, people seem to really revere the Second Amendment above all amendments in the Constitution. We're all sworn to protect the Constitution of the United States and the state of Kansas. Do you hold all amendments sacred like the Second Amendment in the Constitution?
Absolutely.
Thank you. Thank you, Mr. Chairman.
Very good. I have a couple more folks, and then we'll cut this off in the interest of time. We have other people here that need to speak. So with that, Representative Haskins.
Thank you, Mr. Chair, and thank you, Attorney General, for your testimony. And my questions have been asked by my colleagues, except I wanted to just clarify, will this have an impact on your office for the taxpayers to cover? Will this be challenged? Do you anticipate, since we don't have a fiscal note?
It's really hard to predict litigation. And the most likely litigation would be brought by an individual, right? It's an individual asserting that his right to keep and bear arms has been infringed. He would add this more robust state constitutional element to his challenge. The only way it would affect our office is if the individual was challenging a state statute, and of course, it falls to my office to defend that statute. So it's conceivable that it would come into play in such a case.
So if it does, thank you, Mr. Attorney General. So if it would come to play here, here's the two other questions I have on that. Is like, I'm still not sure. Has there been a demand and from your law enforcers and from the citizens stating like this amendment is needed?
There's been a lot of concern and outcry among citizens that I have spoken to, worried about what the ATF, the federal bureaucracy, has been trying to do to go beyond the scope of the four corners of federal statute.
But there's no coherent support explaining why this amendment is necessary. It's just information that you've received from citizens overall. Is that?
Well, I think most citizens, are not attorneys and may not be thinking, okay, how would you fortify your right to keep and bear arms? But I think this significantly does, as I tried to explain, significantly adds to the protection of the right.
And my final question is let's say the federal government comes down and says that one of these firearm accessories is illegal, and then all of a sudden ATF takes away Kansas citizens' arsenal that has this illegal, and they want to sue based upon this, their state constitutional right. How would you side on that?
So if Congress banned a particular type of accessory, and there are lots of bills in Congress to do exactly that, then this amendment would be preempted by that congressional act. Now, if ATF tried to expand its authority beyond what it has right now under this federal statute and tried to ban that accessory, then the individual would have a claim here. It probably wouldn't affect us because the defendant, it depends how the case, maybe the ATF seizes something from an individual or from a seller, and then that individual is a defendant asserting in a criminal case the right to keep and bear arms. The state of Kansas wouldn't be a party in that case.
Okay. I'm sorry. Last question, Mr. Chair. I promise. So if the federal government, if we're going to follow the federal government's laws based upon what is ammunition, what is gun accessory that's legal, why is this necessary? Because it seems like the federal government is already, and we're going to follow that. And the language in here is so broad that it doesn't really give any generalization stating like, would we support the federal constitution first, or would we support state constitution? It just says you have the right to own bullets. And I would think that the Second Amendment would already cover that.
I would think the Second Amendment would already cover the right to own ammunition. But one of the interesting things about the Second Amendment is it's not the least developed amendment. The Third Amendment, which is the right not to have soldiers quartered in your home, is probably the least opined on. But the number of cases that squarely address what the Second Amendment means is fairly small. I mean, you really, as someone looking at it as a constitutional lawyer, you'd look at Heller, then you'd look at McDonald versus Chicago, and then you'd look at New York State Rifle and Pistol Association versus Bruin. Prior to that, you had to go back to the 1930s to see a Supreme Court decision on the meaning of the Second Amendment. I say that to answer your question. There are still a lot of unanswered constitutional questions. To what extent is ammunition covered? What accessories, if are covered, what aren't covered by the Second Amendment? What this would do would add certainty that the state constitutional provision in Kansas does cover those things.
Very good. Thank you. One more question. Committee, I will remind you to be respectful of our conferees. Let them finish their answers before you interrupt. So with that, I have one final person, Representative Haswood.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being here today. These are conversations and topics that we don't take lightly in here. And my mind goes to public safety and wellness of Kansans. And my mind goes to, what are the consequences of this? What doors are we opening, whether it be domestic violence? And I know in the spaces of firearm, school shootings and our children's safety and wellness are always of concern. I'm concerned that this is going to be opening up the doors for folks to get in the wrong hands of these ammunition, accessories, and dangerous components. I was just asking for a clarifying question. I think you guys were talking a little bit about this, but domestic violence. What are the potential consequences that this might bring for those folks?
So you also mentioned, I'll answer your question, but you mentioned in your preface the concern about school shootings. There's a federal statute, the Gun-Free School Zones Act, which was passed in, I think, 1990 or 92 under President Bush. That remains in effect. So that doesn't change. And again, it would not be a lawful use of a firearm to take that firearm, unless you're a law enforcement officer, into that school. So that doesn't change at all. It's still unlawful. And this amendments to our constitutional amendment doesn't change that. With respect to domestic violence, if the individual has been convicted and is deprived of or a court has issued an order depriving the individual of the right to bear arms, this would not displace that order. You could make the case that maybe on the margin someone might raise this as an argument, but I don't see this as changing the outcome in a domestic violence situation.
Okay, thank you.
Very good. Thank you very much, General, for being
Thank you.
here. Next, we have Speaker Pro Tem Blake Carpenter. Welcome to committee.
Thank you, Mr. Chairman, Mr. Vice Chairman, Ranking Member, and Committee. Appreciate you all having me in front of you this morning. And I'm sure you guys are all at the edges of your seats on how I came up with this language. Well, I was at the gym in 2020, 2021, and it just hit me. So started working on it then, started doing some research, found out 4 other states had the strict scrutiny language within their constitutions. Now, if you guys want to hear the flowery language, it's all there in my testimony that's in front of you. I'm not going to read the majority of it. However, I am going to read just a little bit of it, though. So for the record, for folks who are listening online at home that might not have my testimony pulled up. So our forefathers, in their unparalleled wisdom, recognized the right to bear arms as a fundamental liberty, integral to the American ethos. This right was not a mere amendment to our Constitution, but a crucial element in the architecture of our liberties, a bulwark against oppression and a guardian of personal autonomy and security. As we sit here and deliberate on HCR 5020, let us recall that our task transcends mere policymaking. We are upholding a legacy, a sacred trust passed down from those who forged this nation on principles of freedom and self-determination. The founders, in their foresight, enshrined this right to bear arms within the fabric of our Constitution. This right was not an afterthought, but a pillar of our liberty, a safeguard against tyranny, and a cornerstone of our security as a free state. As we deliberate on the merits of HCR 5020, let us remember that we are not merely discussing a policy decision. We are reaffirming a legacy that has been entrusted to us by generations of patriots who believed in the sanctity of individual freedom and the right to self-defense. Our nation's history is steeped in this steadfast belief in our right to bear arms. This right, enshrined in our Second Amendment, was not born out of a whim, but from a hard-learned lesson of history. Our founding fathers have endured the yoke of tyranny, understood the critical need for a populace that could defend itself not only from external threats, but from the overreach of its own government. They recognized this right was integral to the balance of power, a necessary means to ensure that our government remains of the people, by the people, and for the people. Before I open up to questions, I want to answer several of the questions, or at least make a comment, because I'm sure they're going to come my way too. I'll preface this by saying I'm not an attorney. The strict scrutiny I did do research though, so I at least pulled that. But the strict scrutiny is the highest standard of review used by courts to elevate the constitutionality of laws, especially those affecting fundamental rights, such as the right to bear arms. Under this scrutiny, the government must prove that the law is narrowly tailored to achieve a compelling state interest. In the context of the Second Amendment, this means any regulation must closely align with the vital public safety objective without unnecessarily infringing on the rights to bear arms. Now, for the public safety aspect of it, while strict scrutiny protects the right to bear arms, it doesn't prevent the government from enacting regulations to ensure public safety. For instance, the government can implement restrictions to prevent firearm possession by individuals with a history of violent felonies or domestic abuse. These measures are justified as they address a compelling interest, public safety, and are narrowly tailored, targeting specific high-risk groups rather than imposing broad restrictions on all citizens. This approach ensures the protection of constitutional rights while addressing legitimate concerns of safety and crime prevention. With that, Mr. Chairman, I will stand for questions.
Questions, committee? Representative Ruiz.
Thank you, Mr. Chairman. And Representative Carpenter, the words you wrote, or the words you read were very nice. Did you write those?
I did have some help, but yes, I tweaked them and made it my own.
My compliments to you.
Thank you.
Do you think, is there any time a person would lose the right? When we've had several instances brought up about domestic abuse and different situations where a person could forfeit their arms for a while and then get them back. Is there any situation where a person, other than being imprisoned, can lose the right to bear arms or hold firearms?
Well, my understanding is we actually currently have that in place. So if someone's on probation, they're not necessarily in prison, but they're still prohibited from owning or possessing firearms at that point in time, just like with their right to vote. So we have the ability to take away somebody's right to vote. That is a fundamental right. I think we would all agree on that. But if they're in prison or if they're on probation in the state of Kansas, they no longer have the ability to exercise that right to vote until they have served their sentence. And so once they're off probation, that right is then reestablished to that individual under voting rights. Now, firearms might be a completely different story depending on the severity of that individual with domestic abuse, that type of stuff.
Mr. Chairman, if I may, what level of felony disqualifies you from voting or owning a firearm, possessing a firearm?
I would have to get with the revisor on that. And
Mike, you have that?
I believe it's any felony, actually. I'll send out an email to the committee, but I think it's any felony.
Thank you. Thank you, Mr. Chairman.
Very good. Representative Hauser.
Thank you, Mr. Chair. Thanks for being here, Mr. Speaker Pro Tem. Got a couple questions for you. Can you guys hear me all right? You know as well as I do that I'm pro Second Amendment kind of guy. And how will this constitutional amendment, remember last year what came around we were working on? Let's say I own several of those pistol braces and the BATF was coming after pistol braces. How would this protect me from that?
thank you for the question, Representative, Mr. Chair. I think that the Attorney General, being an attorney, he answered it far better than I probably could. But I'll point to his testimony, what his statements were, in the sense that if Congress passes a law on it, then at that point it supersedes what we have. But then if it's just a regulatory scheme that's put on by the federal agency, then I think at that point in time, there would be the ability to have that debate in court.
Okay, follow-up question on that. So we're still leaving it at, so our Second Amendment right is now in the hands of the court with the strict scrutiny thing, instead of just saying shall not be infringed. So, you know, I sat in this room back in here in 2013, and we passed the Second Amendment Protection Act out of here. And matter of fact, I had an amendment or two on that I had part of that. And we all know what happened to that. When the time came for a test, everybody went bye-bye, and there was no protection at all. So how would this bill be enforced? Let's say that BATF does manage to get their pistol brace rule through the court system. How would this bill or this constitutional amendment enforce that if they were going to come in? Well, I get that now. They trump us, but that's just it. We don't have any way any kind of recourse at all, or we're just at the hands of the court system at that time. Is that what I'm getting?
So, Representative, I think you and I have had conversations regarding other constitutional provisions like the 10th Amendment and other discussions and where states' rights begin and end. I think your question is basically getting to that crux of that issue. At this point in time, our government is set up in a way, and I think we have very similar ideals on, to quote Reagan in 1981 for his first State of the Union address, the states created the federal government. The federal government did not create the states. And that being the case, though, under current law and under how the current rulings and everything else and how court decisions have put us in the last 100 years, we are now at a point where we do have to play with the federal government in the sense of when they pass these laws or these types of things, at that until those court cases start getting overturned or changes in, I believe it's called the jurisprudence. Again, not an attorney, but as soon as those court cases start being revisited by the courts and changing it to where states' rights start becoming more prevalent, then at that point we might see a difference or a change in what the SAPA, the Second Amendment Protection Act, and the end result of that issue. But as of right now, where we currently stand as a country, the federal government, again, what the Attorney General said, has the ability to put these laws on us through Congress. Now, that being said, though, the U.S. Constitution is the supreme law of the land. So it doesn't matter if our Constitution says something. If it's counter, if it says, we no longer support the Third Amendment, the ability to, if, no soldiers shall, be housed in homes. Well, we want soldiers housed in homes. Well, we wouldn't be able to say that or do that, even if we put it in our own Constitution, because the U.S. Constitution will still supersede that of our own.
Thank you, Mr. Chair. That's all I have for the moment.
Very good. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee.
Next, we have Rebecca Schmoy, Representative Rebecca Schmoy. Thank you for being here, Representative.
Thank you, Mr. Chairman, Vice Chair, Ranking Member, and Committee. This amendment that we're talking about is not partisan. The clarifying language in this amendment is not partisan. It doesn't expand gun rights. What it does is it restricts avenues for infringement. When we set up the strict scrutiny standard and we treat Second Amendment or our Section 4 as equal to other amendments, such as the First Amendment, that is only better for Kansans and for U.S. citizens. When we treat all of our amendments, when we treat all of our rights the same across the board, that gives us confidence and an equal playing field. Now, it was brought up in the press that this could be a disaster for public safety, to which I ask, would this be the same type of disaster that you predicted and didn't happen with concealed carry, constitutional carry, 18 to 20-year-olds, or removal of the fees? Are we going to see the same disaster in the community that we saw after those? And can any of you name the disaster that we saw after those? Whereas this is not partisan language, where ammunition, components, and accessories are already covered. What I'm finding is that somehow we've been distracted over what the job is. What we're addressing today is not whether or not we are pro or against the language in this constitutional amendment. We are addressing whether or not we trust our constituents in order to put this language to a vote of the people of Kansas. They deserve for us to trust them. They deserve for us to not stand up here and hold their hand or be a gatekeeper for their rights. If you trust your constituents, if you trust the people of Kansas to be able to make their own decision on an issue such as clarifying language on what their Second Amendment, what their Section 4 in the Kansas Constitution, what their natural fundamental rights are, then step out of the way and allow Kansans to have a vote and a voice that is equal to our own while we are standing up here. Anyone, any legislator who feels the need to handhold or gatekeep on this issue, I have to ask you why. What are you scared of? I ask you to trust your constituents. And if you cannot trust your constituents, why should they trust you? I will close by saying that I have spent many years in the protection and the education of gun rights. That is not why we are here today. We are here today to move out of the way and allow Kansans to speak for themselves. And I will stand for questions.
Committee, a few brief questions. Seeing none. Thank you.
Thank you.
Next, we have Travis Couture-Lovelady with the NRA. Travis, welcome to committee.
Just turn it off or leave it on. Mr. Chairman, members of the committee, pleasure to be here today. Always a pleasure to be back before federal and state affairs. As a former vice chair of this committee, it's always an honor to be here, so I appreciate you and all your service. I'm here in support of HCR 5020 on behalf of the National Rifle Association and our members in Kansas. As said before, HCR 5024 amends Section 4 of the Kansas Bill of Rights to ensure the right to keep and bear arms includes essential tools required to exercise that right and ensures the highest level of legal protection in the Kansas Constitution for this fundamental right. Fundamental being the key word here. I want to follow up on what Representative Clayton was asking earlier, just to clarify, and I know this because I wrote the 2016 Right to Hunt, Fish, and Trap with Representative Lusker. That one is different than the one we're talking about, the 2010 one. So the 2010 one was the right to keep and bear arms. The basic language that we're talking about in Section 4 of the Kansas Bill of Rights, the right to keep and bear arms, that we're adding this new language to. So that's different. That was 2010. 2016 right to hunt, fish, and trap was a separate issue. So what is strict scrutiny? Strict scrutiny, the highest level of legal protection. It's reserved for fundamental rights. We believe our right to self-defense in the Second Amendment is a fundamental right, along with free speech, right to vote, and we believe it deserves that protection. For decades, anti-gun judges and lawyers have fought tirelessly against application of strict scrutiny to our fundamental Second Amendment rights. Because this proposed amendment will protect a fundamental right and will expressly acknowledge the right as fundamental, it naturally follows that the protected right requires the highest level of legal protection. Our neighbors to the east already have this in Missouri. We certainly don't want Missouri to beat us, so I think we should catch up. Some have asked why, and I'm sure many more will ask why. We already have the Second Amendment, and the recent Bruin case further explained how that amendment is an individual fundamental right. So why does Kansas need to do this? This will serve as a backup to the Second Amendment. Available federal courts, Congress, or the executive branch ignore or further abuse the protections of that amendment. In addition, its requirement that potential infringements on our right to keep and bear arms must be considered by Kansas courts under the doctrine of strict scrutiny would be a powerful deterrent. Can certainly answer questions, but on behalf of our members in Kansas, I respectfully ask the committee to support passage of HCR 5020.
Very good. Thank you very much, committee. A few brief questions. Seeing none, thank you very much.
Thank you, Mr. Chairman.
Next, we have Mariah Day, Kansas Rifle Association, and I believe he's on WebEx. Is that correct, Lance? Okay, very good. Mariah, welcome to committee.
Thank you, Mr. Chair and members of the committee. So sorry I couldn't actually be there in person today. I'm on the road and wanted to be available if you all had questions. I'll keep my testimony very brief. Essentially, you've heard from other conferees already about what this constitutional amendment does and the importance of passing it. The Kansas State Rifle Association urges you to continue listening to the conferees and to pass this resolution creating this constitutional amendment, giving Kansas voters an opportunity to pass this constitutional amendment. Back in 2008, obviously, as you've heard, the U.S. Supreme Court ruled on our U.S. constitutional amendment, the Second Amendment, in the Heller case. And then shortly after that, the Kansas legislature took action to give Kansas voters an opportunity to pass similar protections under that at the state level through a constitutional amendment, which Kansas voters did overwhelmingly. Again, in 2016, the Kansas legislature gave Kansas voters another opportunity to protect the right to hunt and fish, as you've already heard. That also passed overwhelmingly. I believe the vote was 81.31% of the vote on that one. And then most recently, as you already heard from the Attorney General, the U.S. Supreme Court ruled in the Bruin case protecting our constitutional right to keep and bear arms. I would urge this committee to give Kansas voters an opportunity again to protect the right to keep and bear arms and to raise the protection to the level of strict scrutiny. I'd be happy to answer any questions, but I'll leave it at that. Thank you, Mr. Chair.
Very good. Thank you. Committee. Representative Hoy.
Whoops. Thank you, Mr. Chair. Thank you for the testimony. Oh, we lost him up there. I wanted to go back. I was reviewing quickly some of the testimony from the 2017 domestic violence bill that was passed overwhelmingly here in Kansas. And the conferee, you and I both provided testimony in support of as proponents of that. And I do want clarification on this because I don't believe there is severability in that language in our state statutes that provides prohibitors for domestic violence misdemeanors and stalking orders. And so I'm just wanted to ask you if the Kansas State Rifle Association's position is still the same, that they are supportive of that, those prohibitors in our state statutes.
The Kansas State Rifle Association's position has not changed on any of that. Obviously, as other conferees have mentioned, if someone is committing a crime, they are not in lawful use or possession of a firearm in that situation. And I'll just leave it at that. The Kansas State Rifle Association's position has not changed. We wholeheartly want to keep firearms out of the hands of violent felons and those committing crimes. There's no question about that.
Very good. Committee, further questions? Very good. Thank you, Mariah, for being here.
Thank you, Mr. Chair.
Committee, I'll bring your attention to some written proponents here that are on your list. And now we will go to the opponents. And the first opponent I have is Reverend Annie Ricker from the Kansas Interfaith Action. Thank you for being here, Reverend.
Good morning, Mr. Chair and members of the committee. My name is Reverend Dr. Annie Ricker. I'm the chair of the board for Kansas Interfaith Action, a statewide multi-faith advocacy organization that puts faith into action, speaking for people of faith here in Kansas. Like the overwhelming majority of Kansans, the people of faith who make up KIFA support sensible gun legislation that would address our ongoing epidemic of gun violence. This morning, we continue to pray that our legislators would listen to our pleas. As a pastor living in Topeka, this issue is especially close to my heart. Within the first week of serving my congregation here, I had to make a hospital call to visit a child from my church who had been the victim of a shooting. Gun violence has ended 2 lives less than a mile from my front door. And in 2023, Topeka suffered a record 35 homicides. I have wept and prayed with too many pastors and families and communities of faith who are grieving a senseless loss. Statewide, Kansans already suffer gun violence at rates above the national average, and guns are the leading cause of death among kids and teens in Kansas. I would categorize those statistics as disastrous. People of faith, families, gun owners like me want laws that would keep guns out of the hands of dangerous individuals. This amendment does the opposite of that. Not only would it make it virtually impossible to regulate anything from ammunition to bump stocks and more, when similar amendments passed in other states, convicted felons and domestic abusers sued for access to guns, as we have already heard several times this morning. The right to keep and bear arms is already enshrined in the Kansas Constitution. Our state can protect the Second Amendment while also ensuring that dangerous individuals do not have access to guns by passing and enforcing reasonable gun legislation. We continue to do a disservice to our communities by making it easier for criminals and mentally unstable individuals to access deadly weapons. We cannot truly love our neighbors when we prioritize unfettered access to firearms over their safety and well-being. The denominations in KIFA have made numerous public statements in support of what we call gun sense legislation. My own denomination, the United Methodist Church, passed a resolution calling for gun legislation called Our Call to End Gun Violence in 2016. I've shared that in my written testimony, and I would encourage you to look at it. But today, I'd like to leave you with a prayer from the people of the United Methodist Church. For the people of the USA, resurrect our instincts to honor our common humanity and our compassion to the suffering of our neighbor beyond empty words. For those in positions of power and influence, grant them the will and the courage to protect life over freedom to kill. Lord, in your mercy, hear our prayer. Members of the committee, hear our prayer. Do not pass this amendment. Thank you for your time.
Very good. Thank you very much, committee. Questions briefly. Representative Ruiz.
Thank you, Mr. Chairman. It's good to see you this morning, Reverend. And you made mention that you had 2 children killed in gun violence within several blocks of your house. Are you here in Topeka?
I have not lost 2 children. We had 2 deaths in my neighborhood. We listened to the gunshots from my front door. But I have had a member of my church who was 14 at the time, who was shot and wounded. She was shot in her arm and shoulder and had to have extensive reconstructive surgeries. She was flown to Children's Mercy in Kansas City, and I drove there my 4th day on the job at my church here.
Thank you.
Very good, committee. Any other questions? Very good. Thank you, Reverend, for being here. Next, we have Shannon Little, Moms Demand Action. Shannon, welcome to committee.
Good morning, Chairman Carpenter, Vice Chair Kessler, and Ranking Member Hoy, and members of the committee. I'm Shannon Little, and I'm a volunteer with Kansas Moms Demand Action for Gun Sense in America. Thank you for giving me this opportunity to testify to you today on HCR 5020. The reason that I care about gun violence prevention is because I'm part of the Columbine High School generation that was one of the first generations that had to worry about being shot and killed while we were at school learning. And now I'm part of the Sandy Hook parent generation who worries daily that their children will be shot and killed while they're at school, as well as the Uvalde Elementary School. Growing up, I had a classmate who was a bystander just attending a fist fight, and he was shot and killed. He wasn't part of any of what was happening. He was just a bystander. I was at a family picnic, and we all had to start running and take cover because there was an active shooter when I was growing up. So those are some of the reasons that I'm here today. HCR 5020 would threaten to eliminate some of Kansas's most crucial public safety laws. And on its face, this amendment appears to only broaden gun owners' rights in Kansas, but because of the requirement for strict scrutiny, this amendment would have negative unintended consequences. And if passed, the resolution could pave the way for convicted felons and domestic abusers to legally possess firearms here in Kansas. When a strict scrutiny constitutional amendment passed in Missouri, convicted felons did challenge state laws that prohibited them from possessing firearms. There was a similar change in law in Louisiana that led to a court to declare that the law prohibiting felons from possessing firearms was unconstitutional. I asked the members of this committee to reject the amendment with it the possibility of allowing guns to end up in the hands of convicted felons and domestic abusers here in Kansas. The resolution would also make taxpayers fund the overflow of lawsuits that would be brought by convicted criminal defendants to challenge their ability to possess firearms. In Missouri, the state strict scrutiny law led to significant time and money spent on these cases, and the auditor there projected that it was costing taxpayers hundreds of millions of dollars. On behalf of Kansas Moms Demand Action supporters across the state, I respectfully urge you to reject HCR 5020 and instead spend your time this legislative session passing laws that will make our state more safe and not less. To keep our families and communities safe in Kansas, please reject this amendment. Thank you for allowing me the opportunity to testify in opposition to the bill, and I'd be happy to stand for questions at the appropriate time.
Very good. Thank you very much. Committee questions. Representative Sanders.
Thank you, Mr. Chairman. So thank you for your testimony. In this case, you're demanding basically inaction, that we don't pass this. What actions do moms demand action? What kind of actions do you demand? What is an example of two that would make our state more safe?
We'd really like to see more discussion around secure storage.
Representative Sanders, will you please keep it to the subject here?
Okay. All right.
Thank you very much. We are debating HCR 5020. Okay. And so, okay, very good. Thank you very much for that. Representative Hauser.
Thank you, Mr. Chair. Thanks for being here, Ms. Little. I have one question. You made a statement in your testimony that 5020 would eliminate some crucial public safety laws. Can you give me an example?
The examples I would give you were referred to in the other testimony of allowing convicted felons and domestic abusers to possess firearms. They could challenge those laws, and the concerns have been brought up by some of the other committee members' questions, and that's what we're concerned too, is that some of those laws that are already on the books that bar convicted felons and domestic abusers from legally possessing firearms in Kansas would be challenged in court if this amendment passes.
Okay, so let's pretend like I've had 6 DUIs and I got to go to jail and I can't have a firearm anymore. Let's say I did my time. I can't even go hunting anymore. So Is that kind of what you foresee? I mean, that to me is like, or even like you for in jail for marijuana possession or something like that. You can't get your right back after you serve your time, is because that's where you're worried about the felons and domestic abusers would come in. You know, if a felon has served his time, should not his rights be expunged or whatever? I don't know the correct word to use there, but
I would be concerned for public safety if someone who was convicted of a felony was given his rights to a firearm again.
all right. Thank you, Mr. Chair.
I have a point of information on that, Mr. Chair. Our state laws as well as federal do have certain time periods that are prohibitors for differing levels of felonies. So, and in HB 28 and HB 2058 a couple years ago, we changed those down to 3 years and 8 years from 5 years to 10 years. And the only lifetime prohibition that we have in Kansas is if a felon actually used a gun in the crime.
Representative Resman.
Thank you, Mr. Chair. Thanks for being here today. In your testimony, you mentioned about in Missouri, convicted felons challenge state laws. You know if there was an outcome in that court case?
I do not know the outcome, but I would, if I could, maybe the revisor's office may know. I don't know the outcome in that. Or I can ask and find out for you as well.
Just curious since it's mentioned.
We can check into it. I don't have it off the top of my head.
Committee, further questions? Very good. Seeing none. Thank you. Thank you for being here. Next, we have Grace Springer. Grace, welcome to committee.
Thank you. Good morning, Chairman Carpenter, committee members, and staff. Thank you for allowing me to testify this morning. Again, I'm Grace Springer. I'm a junior at Olathe East High School. I am testifying today because HCR 5020 is a dangerous resolution that poses a direct threat to Kansas public safety laws that protect our communities by keeping guns out of the hands of people who we all agree shouldn't have them. I've grown up with school shootings and shootings everywhere. I haven't known a world where there hasn't been a time without it. I've always been scared of going in public. I've always noticed where the exits are in every building I'm in. March 4th of 2021, I guess paid off one day as a firearm was brought into my school and 3 people were injured that day. I was terrified to go anywhere after that. I worried another shooting would happen at any time, and nowhere I went felt safe. Because of my experiences with school shootings and gun violence, I believe that HCR 5020 will result in higher accessibility to guns, and this accessibility will lead to more safety concerns. People shouldn't have to fear going out in public because of the increased accessibility in firearms. According to every stat, with an average year within Kansas, 456 people die by guns, with a rate of 15.7 deaths per 100,000 people in Kansas. Kansas has the 21st highest rate of gun deaths within the U.S. Imagine how much those numbers are going to go up if HCR 5020 is passed. Now, through the increased accessibility of firearms this bill would propose, there will be a large risk for felons, domestic abusers, as we have heard, and children to get their hands on firearms. This could lead to many more incidents like what we saw at my school happening. The accessibility of guns must be avoided because the consequences are far more drastic than we want to deal with. We have already heard about the tax fluctuations as well within places like Missouri that the strict scrutiny laws would call. I encourage members of the committee to vote no on House Resolution 5020. This concludes my testimony. Thank you for giving me the opportunity today.
Very good. Thank you. Thank you for being committee. Questions? Representative Thomas.
Thank you, Grace. Thank you for being here. You had mentioned you'd grown up around school shootings. Was Olathe East the first one you've experienced? Because it sounds like you've been through them before.
No, Olathe East was the only shooting I was involved in.
Okay, thank you. I do think it's worth pointing out when you talk about the 3 that were injured at Olathe East, it was an assistant principal, the SRO officer, and the perpetrator. The system worked. The security measures in place, and my compliments to Olathe School District. I only bring that up because my daughter was in the classroom right next to the office while the school shooting was happening. So I know exactly what you're going through because my daughter's been through it myself. So I appreciate you coming today. I just wanted to make that point that the 3 people injured were the SRO officer who got shot, the assistant principal, and the perp. So students survived because someone was present with a firearm, and the security measures the school district had in place worked. Thank you, Mr. Chair.
Very good. Thank you. Representative Haskins.
Thank you, Mr. Chair, and thank you for testifying. To be a student of your age, to come up here in front of this group demonstrates a courage that I didn't have when I was your age, and so I thank you for that. I want to ask you a couple of questions in reference to what you have at your school, which is on topic for, I wonder, do you have a 3D printer that would be capable of making ghost guns in your school if not followed by or observed?
So there's multiple 3D printers that can be accessed by children pretty much anywhere. While we do have them in our 3DE program, I believe, I haven't participated in it, so I couldn't tell you anything. But our public libraries as well also have access to 3D printers that are free to use. So kids could pretty much get access to these ghost guns at any point, and there are like markets that are dealing them as well, which makes this increasingly dangerous.
Very good. And so the right to possess ammunition, even though they don't have a gun, would that be able to help?
Representative Haskins, will you please, we are debating HCR 5020.
Yes, sir.
Okay.
I'm making reference to
So,
the ammunition, the right to possess ammunition.
All right. Try to keep it on the subject that we are debating.
Yes, sir. So the students would be able to have access to the right to possess ammunition based on this amendment, in your opinion. Is that correct?
Well, I mean, the amendment doesn't say that students are going to, but I'm saying through whether increased accessibility through parents like buying guns and not storing them properly, or through children just, like breaking the law, because kids do that. They're kind of stupid sometimes. Kids are going to be able to get access to guns in unsafe ways if this bill is passed, more than we're already seeing.
Thank you very much for being here. Next, we have Claire Reagan, and she's on WebEx. Oh, Grace, could you come back up here for a very quick minute? Representative Clayton.
Oh, yeah, I will keep it to seconds, Mr. Chair. Grace, I really want to thank you for being here. I appreciate you for representing students. As a mother, when I saw what unfolded at your school, I was very frightened on your behalf and on the behalf of a lot of students. Grateful to the city of Overland Park for a lot of their response as well, and for the city of Olathe. But I also want to say that any system that allows that to occur is not a system that worked. What happened at your school and what happened to you and what you went through is not okay. Thank you.
Thank you.
Very good. Next, we have Claire Reagan, WebEx. Claire, are you there? Welcome to committee.
I'm here. Chair Carpenter, Vice Chair Kessler, Ranking Member Hoy, and members of the committee, thank you for providing the opportunity to submit and give testimony. I am here today to voice my opposition to HCR 5020. This amendment to our Constitution could limit the ability of law enforcement to intervene if convicted felons possess dangerous and illegal devices, as well as expand gun access to dangerous individuals, including domestic abusers, as seen in other states and as already discussed. The frequency of school and mass shootings across our nation is sobering. Guns are the leading cause of death for teens and kids in our country. Our children and the educators who teach and care for them should not need to learn how and when to run, hide, or fight. They should not have to learn how to stop the bleed. They should not have to worry if today will be the day they don't go home from school. Parents, grandparents, and even hunters and other gun owners want laws that keep guns out of the hands of dangerous individuals. Conversely, this amendment to our Constitution could allow convicted felons and domestic abusers to own guns and to have the ammunition they need to use those weapons. a sure threat to the safety of all Kansans. Personally speaking, I became an outspoken common sense gun law advocate in 2018 after the tragedy in Parkland, Florida, because the issue stirred my heart. As a parent to 3 young children, well, at the time it was only 2, as a classroom teacher at that time, and the wife of a classroom teacher, I began this journey as an advocate. However, gun violence directly impacted my family in August of 2022, when my aunt and uncle both died by suicide using a gun. From 1999 to 2022, states with our nation's most permissive gun laws, like Kansas and Arizona, where my late aunt and uncle lived and died, these states saw a 39% increase in suicides completed with a gun. The loosening of gun regulations will have unintended and tragic consequences. You can protect the Second Amendment while also ensuring that dangerous individuals or those experiencing an acute mental health crisis don't have access to guns by passing and enforcing reasonable gun laws. You do a disservice to our collective safety by making it easier for criminals and those who are mentally unstable to access deadly weapons. To the notion that we should trust Kansas voters, it seems to me that passing or rejecting amendments to our Constitution in the larger voting arena does little to deter legislation that flies in the face of those Kansas voices. The ball will be back in your court, and I would like to respectfully ask that you vote no on HCR 5020. Thank you so much for your consideration, and I can stand or sit here in my kitchen for any questions.
Very good. Thank you very much. Representative Thomas.
Thank you, Mr. Chair. Thank you for being here. I didn't see in your testimony, are you here on your own behalf or as a board member? Are you representing the opinion of the Olathe School Board today?
I'm here as myself, as a mother, as a former teacher, and as a voter in Kansas, as written in my testimony.
Okay. Real quick, second question, if I may, Mr. Chairman. We heard a minute ago that the system didn't work in the Olathe East school shooting. Could you talk about what Olathe is planning to put in place to make sure what happened in Olathe East didn't happen again, if that's appropriate? If it's not, tell me. Okay.
Representative, thank you for that, but we're debating HCR 5020.
Okay.
So let's keep it on that
Sure.
subject. Very good. Committee, further questions about HCR 5020? Seeing none, thank you very much for being here. Next, we have Danielle Teamlow. Danielle, thank you for being at committee.
Staff. Oh, thank you. My name is Danielle Twimlow. I'm here today as a mother, a grandmother, a public health educator, and a friend to many survivors of violence, which leads me to strongly oppose HCR 5020. We acknowledge the constitutional right to bear arms. It is crucial to consider the potential consequences of hindering our ability to address firearm-related deaths and the subsequent economic impact. I do want to go from my written testimony that I have today to point out a couple things first and foremost that we heard here, specifically around the Bruin case, which, as the Supreme Court handed down, I do want to reiterate that this case was specifically a 100-year-old rule in New York on gun safety that was requiring a license to carry concealed weapons in public places as unconstitutional. So before this law kind of made it illegal for pistols to really even be out of your house, right? So something that we're well beyond with our current laws in place. But I do want to note that a written summary from this ruling by Justice Brett Kavanaugh in concurrence and joined by Chief Justice John Roberts noted that the Second Amendment still allows various gun safety regulations, affirming a central holding of Heller. They said states still may limit guns so long as they employ objective tests. Justice Kavanaugh listed a few presumptively acceptable regulations, including background checks. This concurrence will be key as Second Amendment litigation moves through lower courts. So, highlighting the fact that while this case was setting a precedent, they felt that very likely that states should be still considering some laws in place that are going to withhold public safety standards. Kansas currently ranks among the least restrictive states on firearm regulations, despite a majority of Kansans supporting more robust measures. We all know from the Attorney General's office on their child death reporting that firearms are the leading cause of death among children and teens. It comes directly out of our state report. Yet here we are, having this conversation, hearing our stories of our constituents who have been impacted, hearing stories from children, hearing that children are dying at a high rate in our state. And as we've heard before, that disaster that we have defined being from 2012 to 2021, gun deaths increasing by 32% in our state, gun suicides increasing 14%, and gun homicides 102% since 2012. So perhaps it might be a little more interest to maybe discuss the cost of gun violence, not with a human aspect, but of money. An economic analysis indicates that Kansas bears the 22nd highest per resident cost of gun violence in the U.S., totaling $5.7 billion annually, with taxpayers covering $95.1 million of its burden. The economic toll includes medical expenses, lost productivity in the workplace, strain on law enforcement and our medical resources, and ongoing mental health care costs, among many, many more. Considering the firearm industry's role in Kansas, a report by WalletHub ranked the state the 13th highest in reliance of the firearm industry, using weighted metrics such as gun industry immunity, least restrictive gun laws, and having low minimum age to purchase and possess firearms. However, despite this high dependency, Kansas ranks the 4th lowest in all states by taxes paid by the firearm industry per capita, and their overall economic contribution to Kansas is the 15th lowest in the country. Firearm dealers in Kansas are subject to little oversight, with no state license fees required, while small business owners and other hardworking Kansans have much higher burdens to meet that are often very costly. Limiting our ability to adapt and strengthen gun laws risks perpetuating a cycle of violence that directly impacts the state's economic well-being. Legal terms like strict scrutiny we have heard over and over again. I do want to point out that it has also been proven within our state attorney general's office, even within this year, that it doesn't matter how winnable a case is, there are still people who are going to tie up our court systems with taxpayer dollars to prove a point, regardless if it's winnable or not. So limiting this ability is going to burden the legal system with defending public safety measures already in place that aim to protect survivors of domestic violence and others. In conclusion, I urge you to oppose HCR 5020. The data highlights the adverse consequences of lax firearm regulations on public safety and our economy. It is our duty to prioritize citizen safety and well-being by retaining the flexibility to address evolving challenges that we have yet to see relating to firearm violence while fostering a thriving economy. Thank you.
Very good. Thank you for that. Committee questions. Representative Sanders.
Thank you, Mr. Chairman. Thank you for your testimony. So given your references to the United States Supreme Court, do you think if this legislature puts 50-20 on the constitutional ballot question and the people voted in, do you believe there's a reasonable chance the U.S. Supreme Court will throw it out?
Who knows, right? Like, I'm surprised every day by some of the decisions that are made. However, putting the burden on educating people as a whole on public safety measures back on the people, when it really should be the responsibility of this legislative body to make sure that what we put in front of people makes the most sense, and that it is in the best interest of public safety and health of people. So stopping it before we ever get there, before we ever have to make those decisions and tie up systems, which would likely take years, is the responsibility of now, here and now.
Thank you, Mr. Chairman.
Committee questions. Seeing none, very good. Thank you for being here. Okay, committee, that I will close the hearing on HCR 5020. And I think tomorrow we will hear the Shawnee Mission Indian 2208. So tomorrow we will hear that. So with that, we're adjourned.